Alrighty, hello there, folks. Here we are. Okay, yes, and we are going to be looking at the reply. I've read it all. Letting you know, I'm going a little bit early here because I want to try not to overlap with Millbilly if I can. So if Millbilly can do me a favor and maybe start just about 10 or 15 minutes later, or just wait till I'm done here, I think you'll find I'll be done before the quarter hour. Anyways, so as I went through, I made a few notes of some things that I just wanted to show you, talk about a little bit, and everything. So I think I can do this in about 30 minutes, and then that way Millbilly can go ahead and do his reading of the entire thing as he's planning to do, and everybody can be at both, right? So that way it's good for everybody. So, all right. All right, so here we go. Ready? All right, so I already showed you guys earlier, if you watched my live from a little bit earlier. I showed you guys some of the opening there in the reply. So I will go ahead and get the reply up here now. Okay. So this is the reply. And obviously one of the interesting things in this reply is obviously the talking about the judicial estoppel, which is interesting. So I'm going to go ahead and we're going to go to page 5. Let's see here. Okay, so right here on page 5, it talks about the standard, for or the 3 prongs for judicial estoppel, essentially. So what it says here is that the reviewing court determines de novo whether the elements in the judicial estoppel apply to the facts in the case, right? 3 elements are required for a court to invoke the doctrine of judicial estoppel. Number 1, the later position must be clearly inconsistent with the earlier position. The facts at issue should be the same in both cases. And 3, the party to be estopped must have convinced the first court to adopt its position. Okay, so what that comes down to is how Stephen Avery meets that standard is number 1, the state's current position that Mr. Avery is procedurally barred is clearly inconsistent with the state's September 18th, 2017 agreement with Mr. Avery that he could amend his petition. You see, at one point it was in their favor to be, agreeing, and they were perfectly willing to allow Stephen to do more testing and amend his motion, which is essentially what's happened in a different way, but it's essentially what has happened. So for them to now try to say that they are in opposition and that Stephen should be procedurally barred from something that they already agreed to previously, or at least didn't object to, when Zellner said a bunch of things and represented a bunch of statements from this, basically, on behalf of the state in a filing, and they didn't offer one rebuttal to it at all. They said not a peep. So that's right there. It's in the filings. It's there to be seen, and there is no rebuttal of it by the state ever. So that clearly shows that they were on board to allow, in terms of the agreement that had been arranged, they were willing to allow more testing, and they were willing to work with Zellner. So the fact that they once held that position and they are now changing their position because now it suits them, that they are now saying Stephen is procedurally barred from being able to bring new evidence or any of those types of things and all that sort of stuff. So they have basically changed position, and that's what this is about. So because they've done that complete flip-flop, because it suits them, and the facts are the same, that means all 3 parameters are met. So in essence, we should see this should become a real thing here. The appeals court should take this seriously, by my mind. But let's see what Travis says here. She was brilliant on that. So it's all going to come down to that, whether or not the Court of Appeals believes the argument should control, or whether they think the circuit court should have been appraised. So there'll be we'll have to see, folks. According to what Travis is saying here, we're just gonna have to wait and see what the Court of Appeals does. That's basically what that comes down to. So, but it's interesting. It's extremely interesting. And folks, I will be dancing a jig if the state gets procedurally barred. I tell you, I will be dancing. I'll dance it on live video. I'll dance a jig. Anyways, yeah, if the state gets procedurally barred, oh geez, I will be extremely happy that day. Hey Jamie, how's it going, buddy? Hello Michelle Brennan. Hello Kelly. Hello Jennifer. Hello Cherie. Quickly look at who we got here. Hey Sapper Cop. All right, moving on, because I don't want to move. I want to try to get done before Millbilly and give him time to go live as well. So moving on to page 7 now. If we move to page 7, it just occurs to me that the more she let me see. Let's see, where was it at? I just think that the more that Zellner in this motion, and she's doing it right here, basically, the more in this motion she talks about the agreement made between her and the prosecution and that sort of stuff, and how that was all going on right when the original post-conviction motion got denied. I'm just wondering how much of an effect by her continuing to talk about that agreement and having the Court of Appeals see how closely that resides to the original denial and stuff, if that might be strategic in any way. I don't know, but it's something that occurred to me. So if we go to this one here, okay, so the bottom of 7 here and the top of 8 is very, very interesting, because she's saying the state argues 13 times that Mr. Avery failed to prove his facts and disprove the state's case. Let's see here. Conceding that an evidentiary hearing is the forum to prove factually supported claims, the standard is that the facts must be assumed to be true in determining whether to grant an evidentiary hearing. Okay, the state fails to assume Mr. Avery's facts are true as the standard requires. The state reverts to a sufficiently proven standard which does not exist. Mr. Avery is not required to prove the facts supporting his claims before this court. It's in one of my videos, Travis. It's in one of my videos. I've posted the link 100,000 times. You clearly haven't watched it. But it's in, there's a couple sentences in one paragraph of a fairly long letter to Judge Sukowitz. But doubt away, my friend, doubt away. So anyways, the part that I thought was funny here is she's basically talking about the state is referring to a standard that doesn't even exist, right? So, all right. Hold on just a second there, folks. All right, back. Hello. Okay. So, all right. So moving on now, we're going to go down to page 9. And so where is, I think it's right here, right? Yeah. Avery has this. Let's see. I think it was this one here. Hold on. Oh no, it's this one here, I think. So, Mr. Avery's indigence and lack of legal training were not sufficient reasons, the state's brief claims. Avery's assertion that he was incapable of recognizing and raising legal claims was demonstrably false. The circuit court remarked that Avery's pro se motion recognized significant legal issues, which the court previously ruled on. Right? Significant legal issues, they say. Right? Back, that's what they said. That's what they're saying now. Right? So, all right. However, the circuit court's recent opinion is disingenuous because the circuit court previously ruled that Mr. Avery's claims in his pro se motion were unsubstantiated, empty and without substance, and completely meritless, bordering on frivolous and wildly speculative. Okay? That's the circuit court's previous description of Stephen Avery's pro se appeal. But now, because they want to be able to procedurally bar it and all that sort of stuff, now they're arguing that it was a good filing. He had merit in blah 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 and all that sort of stuff. So, anyway, so that's what that's basically getting at. KZ has laid out a much better case on the denial of an evidentiary. She killed them on denial of evidentiary hearings. So now we're going to move to page 18. I'm going to go back and do another video on this probably, folks, but this is just the things that popped out at me on my first time through. So this one's interesting because remember the state was saying how Stephen Avery had never mentioned the preservation order in any filings or anything, and that therefore he's procedurally barred, even though that would have made him. They even said if he had mentioned it, then that would have been a potential way to have success for him, and stuff. And so here she is pointing out that yes, we did mention it. We mentioned it in this filing on whatever. And so she's talking about right now how the preservation order was mentioned. And so anyway, so here we go. Ready? Mr. Avery properly argued that the state's refusal to vacate his judgment violated the 2007 preservation and testing order. The state incorrectly asserts that Mr. Avery failed to raise the argument regarding the circuit court's violation of the 2007 preservation and testing order, claiming the argument appeared in none of Avery's motions to the circuit court. However, it did. In his second amended supplement to his motion for reconsideration, Mr. Avery pled the effect of the court's failure to vacate its October 3rd, 2017 ruling is that it has unilaterally blocked all future scientific testing in the Avery case, in direct contravention of the April 4, 2007 order entered by Judge Willis. So there it is. It was in a filing, and it is there, and she has just pointed it out. So by all rights, if the state said the only reason Avery wasn't going to find success on that claim was because he hadn't mentioned it, well, whoops, there it is. It's mentioned. All right. So take a quick look at the chat here. And actually force one, that hearing would encompass every fact that KZ has presented. Correct. They actually have all the discretion. They could make it, they could decide the scope of what she's looking at or what she's allowed to do. I would imagine the Court of Appeals has a great deal of freedom and discretion to do as they would please. And I would imagine that they could certainly, decide the size of the scope, is my best answer for that one. There's not a deadline now. It's going to be waiting for the Court of Appeals to make a decision, and they will write a decision at some point. Probably won't happen very quickly. I would say we're going to be waiting at least a couple months, up to maybe even 6 months or so. Who knows with COVID-19 right now, with the courts being backed up, maybe even a little longer. Who knows? It's hard to tell, but basically we're going to be waiting for a decision now. So, all right, moving on to my last one. We're going to be able to finish up here and and so we don't have to, conflict with Millbilly, and you guys can all go over and check out his reading. All right, so moving to the last thing. Page 24. Now, you guys know all this talk about piecemeal, and all that crap, right? So I just want to read this because it's very interesting. Let's see. Even so, the state accuses Mr. Avery of filing in a piecemeal fashion. Filing under the same case number is, by nature, not piecemeal. Not piecemeal fashion. Filing under the same case number is, by nature, not piecemeal litigation. Supreme Court recently held that a Rule 59E motion to alter or amend a habeas court judgment is not a second or successive habeas petition, but rather part of the first full petition. Mr. Avery's motions and supplements were all filed under the same case number and are all simply a continuation of the same proceeding. See Gonzalez versus Crosby. Issue preclusion doctrines are inappropriate where the record reflects that the petitioner is diligently pursuing his claims and supporting facts in his first meaningful post-conviction review. Holding that abuse of the writ doctrines have no application in a first habeas corpus proceeding, and Williams, holding that a prisoner who acts diligently to pursue his claims has not failed to preserve his right to a hearing on those claims. So, interesting stuff. So that's, for me, I wanted to point that out because just because of the piecemeal stuff, you continuously hear about the piecemeal. Number one, because it's all being filed in the same case number, Zellner saying, no, it's not piecemeal when it's being all filed under the same case number. If the state's complaining about the fact that Zellner's having to file multiple filings because of the way that they're popping up with a CD here, and then we're discovering that they were hiding the bones they gave back and the ledgers that proved it, and we find out that they're so we're finding all about we're having to find out about these things that the state has done, and so now they want to complain that Zellner's having to file more filings. Well, it's kind of your own fault, isn't it? State of Wisconsin. Wah. I'm gonna call you the Wambulance. I'll call you guys the Wambulance right away. So, all right. That was mainly the last thing I want to show you guys. There is an interesting thing here where she shows all of her newly discovered evidence that should be assumed true with the state's, basically what the state says about it over on the right side here. So it's like about, I don't know, around 10 pages or so. Interesting stuff. So I'm going to go ahead and check out now. Let everybody head over to Millbillies Live. And like I said, I'll be going back in on this again this weekend. And hey, Scooby, how you doing? And so yeah, that's about it. Everybody head over to Millbilly. I know he's getting ready to kick off if he hasn't already. Those are the few things that jumped out to me on my first reading. But like I said, I'll be back to cover it some more. If you haven't already, please hit subscribe, and we'll see you.